Forward. A citizen's plea for justice. This court is no stranger to momentous cases that test the strength of our democratic institutions. But rarely has it confronted a record so replete with official misconduct, so riddled with breaches of the public trust, as the one now before it. What follows is an account of a citizen's Kafkaesque odyssey through a legal system that has lost its way, a haunting portrait of government unmoored from its constitutional bearings. For nearly a decade, I have navigated a labyrinth of administrative and judicial processes in search of a simple thing: accountability for those in power who abuse their positions and trample on the rights of the governed. At every turn, I have encountered a system more interested in protecting its own than in upholding the laws and principles it is sworn to defend. From the Attorney General's office to the Ombudsman to the lower courts, the institutions that should serve as bulwarks against official overreach have instead acted as enablers and co-conspirators, shirking their duties and abandoning their most basic obligations to the public. The result is a spreading rot at the heart of our civic order, a gnawing sense that the fix is in, that the powerful can act with impunity while the powerless are left to fend for themselves. The record compiled here bears out that grim assessment in exhaustive detail. It chronicles sham investigations and bad faith prosecutions, open records obfuscations and open meetings lockouts, whistleblower retaliation and judicial rubber stamping. Taken together, these abuses amount to nothing less than a wholesale assault on the concept of Republican self-governance, a concerted effort by entrenched elites to insulate themselves from meaningful scrutiny and consequences. As a citizen who has borne the brunt of that assault, I come before this court not just as a litigant, but as a sentinel sounding the alarm about the fragile state of the rule of law in our state. I have seen firsthand how the mechanisms of public accountability, built up over generations to ensure that the people remain the ultimate sovereigns, are being systematically dismantled from within. And I have watched with growing dismay as the very institutions charged with defending those mechanisms retreat into a cocoon of willful blindness and complicity. This petition is the product of that long and dispiriting journey, a painstakingly documented attempt to force a reckoning with the unpleasant realities that Nebraska's power class would prefer to ignore. If successful, it will be despite, not because of, a system that has told me at every juncture to sit down, shut up, and accept the steady erosion of my basic rights as the cost of doing civic business. In that sense, the verdict rendered here will be about more than the disposition of any one complaint, any one controversy. It will be a defining statement about whether the ideal of open government still has any purchase in an era of metastasizing secrecy and subversion. It will determine whether our state's highest court has the institutional backbone to confront the painful truth of our democratic decay, or would rather pull the blinds and pretend all is well with the world. For my part, I have shed too much blood, sweat, and treasure in this fight to mince words or pull punches. The system to which I have appealed for redress has defaulted on its most solemn duties, betraying the public faith and leaving citizens like me to twist in the wind. Any court worthy of its name and station must acknowledge that hard reality before it can hope to chart a path forward. With that in mind, I respectfully demand that, before proceeding to the merits of this petition, the court take 2 concrete steps to begin restoring a baseline of public confidence and good faith. 1. Waive all fees, costs, and monetary obligations associated with this proceeding and with my decade-long battle for transparency and accountability. It is obscene to expect citizens to bear the financial burdens of a system that has failed them so completely and that now holds the keys to their last chance at justice. 2. Commit to providing me a full and fair opportunity to present my case in open court, including the right to call and cross-examine witnesses and to introduce all relevant evidence of official wrongdoing. Anything less would make a mockery of the adversarial process and reduce this proceeding to a foregone conclusion. I make these demands not in a spirit of pettiness or entitlement, but as a necessary predicate for any meaningful reckoning with the profound issues at stake. They are a litmus test of whether this court is prepared to treat this petition with the seriousness and urgency it warrants, or whether it will retreat into the same culture of denial and minimization that has brought us to this point. The record that follows will leave no doubt as to the depths of the rot that has taken hold in our state's governing institutions. The question now is whether this court will have the courage and clarity of purpose to excise that rot at the source, or whether it will choose to avert its eyes and let it metastasize further. Nothing less than the future of self-government in Nebraska hangs in the balance. As a citizen who has given more than any should have to in defense of that precious birthright, I can only hope that our state's highest tribunal will prove itself equal to the moment. The hour is late, but not yet past, to breathe new life into the old adage that where there is a right, there must be a remedy. Let the proceedings here determine whether those words still have meaning, or whether they will join the mounting pile of dead letters in our fraying constitutional order. Finally, there should be an opportunity for me to confront the AG, UPL, Ombudsman and school district in front of this court, so that they can stand in front of the justices and explain why they have chosen to violate every basic rule and statute of the law, defame, slander and gaslight me, and answer in public for their horrifying abuses of their trusted authority. Nothing short of an actual public evisceration of these years of lies, forcing the abusers to face the target of their own destruction in a forum where they are on equal footing, can provide the very sobering reality of the entrenched Nebraska sham of a legal system. No amount of procedural flops, cozy relationships, improper punctuation or lack of elegance can change the hard, cold facts that I have extensively documented, and no one who has perpetrated such abuse on a citizen should be allowed to receive their punishment through an informal email or conversation. Everyone is entitled to face their accusers. This has been one constitutional violation after another. According to the UPL, I have until October 22, 2024, which is very little time for this court, but it wasn't until late last week that the UPL stated that due process was less important than hiding their lies. It's imperative that this tribunal immediately take action to stop any action against me, as there is simply no possibility of the existence of the evidence the UPL claims to have. It's not real, it's retaliation for exercising my own personal self-advocacy, it's intimidation, it's illegal, it was sent on National Wrongfully Convicted Day, and these state-sanctioned abusers are no less dangerous than a terrorist strapped with a bomb in your courtroom. Due to all of the significant factors that affect every citizen in the state, this situation deserves nothing less than an immediate hearing. I still have great respect for the Nebraska Supreme Court, despite the intentional sabotage from everyone below, and consequently, believe that you will rise to this challenge, despite the uncomfortable facts I am bringing. Thank you, sincerely. Justin Riddle. Pro se litigant and defender of American freedoms. In the Supreme Court of Nebraska. Justin Riddle. Petitioner. B. Nebraska Commission on Unauthorized Practice of Law, et al., Respondents. Petition for extraordinary writ of mandamus, prohibition, and supervisory control. Introduction. A Republic in Twilight. This case is no ordinary matter. It is the culmination of a citizen's Kafkaesque odyssey through a legal system that has lost its way, a haunting portrait of government unmoored from its constitutional bearings. It is the story of Justin Riddle, a man who dared to shine a light on official misconduct and found himself engulfed in a nightmare of retaliation and cover-up, his rights trampled and his evidence suppressed at every turn. What began as one man's quixotic quest for justice has metastasized into an existential threat to accountable self-government in Nebraska. The voluminous record appended to this petition documents a hydra of interlocking scandals, each more egregious than the last. The Commission on Unauthorized Practice of Law initiating disciplinary proceedings against petitioner while refusing to provide him the complaint or any notice of the charges. A Star Chamber reborn. Commission on Unauthorized Practice of Law of the Nebraska Supreme Court. 1 SSION members Ankflabrum Pfister, Chair Prone, O. Brent Wolzen Fax 4,024,711,014 Terra HOLTERIALSAR 1 ATSWA Evzeret Jupi CH Counts LONUPLERMIECASTILLO Hiarco Weber Janet Bonet. October 17, 2024. Justin Riddle. 16,422 Patrick Avenue. Omaha, Nebraska, 68116. JustinRiddle1@gmail.com. In re complaint to the Nebraska Commission on Unauthorized Practice of Law. Mr. Riddle. This correspondence is in response to your public records request of Friday, October 11, 2024, which was received by my office on Tuesday, October 15, 2024. You requested all records related to the alleged unauthorized practice of law UPL complaint against Justin Riddle, including but not limited to 1. The original complaint filed against me, along with any and all supporting documents, evidence, or exhibits. 2. All correspondence, including emails, letters, and memoranda, between the Counsel for Discipline and any other parties regarding the complaint. 3. All investigative reports, notes, or other documents created or compiled by the Counsel for Discipline in relation to the complaint. 4. All legal analyses, opinions, or memoranda relating to the complaint or the alleged UPL violations. 5. All communications or documents relating to the decision to initiate formal charges against Justin Riddle. Your request for records is denied. Such records are records of the Commission on Unauthorized Practice of Law and thus are confidential pursuant to Neb. Court. R. Section 31020b. In addition, such records may be withheld under the Public Records Act, Neb. Rev. Stat. Section 84 to 712.055. R. File 240702. Nebraska Commission on Unauthorized Practice of Law. Of the Nebraska Supreme Court, page 20 F2. Pursuant to Neb. Rev. Stat. Section 84 to 712.041 C. You are hereby notified that you may have a right of review of this decision under Neb. Rev. Stat. Section 84-712.03. Sincerely. Mark A. Weber. Counsel for Discipline N. The Unauthorized Practice of Law. Ma. ETP. The Attorney General conducting a sham investigation into Open Meetings Act violations by Omaha Public Schools, then brazenly misrepresenting its findings to deflect accountability when confronted with video proof of the lies. The level of arrogant disregard for the rule of law is on stunning display when the Attorney General is comfortable putting two statements impossible to reconcile on the same page of a published opinion. Ontent of their speech next comp, AMA N, SAW, leg MNDWL.ZYSWDENER ed UXTHE AC fight to speak based on their unwillingness to state their address. A review of the video of the August 2, 2021 meeting shows that 13 members of the public requested to speak at the meeting. All members of the public wishing to speak were able to do so except for two speakers, Cheryl Adamson and Justin Riddle. The video shows that at January 6, 2022. Page 200 GE equals TA FAVAW OOIY ETVRS smiley face GTN equals to O equals 51 please. For her address and he beginning of Ms. Adamson's comments, she a. Ms. MSON was underscore Allo responded, my husband wouldn't appreciate that continue and spoke for approximately 1 minute. Ms. Adamson that the board needed her public comment and not someone else's. Ms. Adamson did not respond and continued to play the audio recording. Ms. Adamson was then escorted from the podium by security shortly thereafter. Later during the public comment session, the video shows Mr. Riddle approach the podium and state his name, but also stating that his address was irrelevant, and he was not required to give it. Dr. Hallman responded that it was a statutory requirement that he give his address. Mr. E continued to argue and state that he was not required to give his address. Mr. Lempted to proceed with his comments and the board cut his microphone. Mr. Int at the podium for approximately 20 seconds and then appeared members of the audience before approaching the board table. At Thafin asked security to remove Mr. Riddle and he was escorted out of th. Adamson. My husband wouldn't appreciate it. Being an ops and Metropolitan Community College teacher for 36 years, there's one thing that is ingrained in my brain and that is to be, asterisk while Neb. Rev. Stat. Section 84 1412 1 PRDILDES that the public has the right to attend and speak at meetings of public bodies. Section 84 1412 2 allows public bodies to make and enforce reasonable rules and regulations figuring the conduct of persons attending, speaking at, videotaping, televising, photographing, broadcasting, or recording its meetings, including meetings held by virtual FI conferencing. Subsection E of ITML Board Policy Number 8346 states that, Emberg IOF the public will be permitted to speak at board meetings at which a public comment ISFBN the agenda, and may speak during the time at which the public comment agenda ITF is being addressed. In addition, policy number 8346 inches requires that members of the public identify themselves, spelling their name, stating an address and the name of any dignization the member of the public is representing. This address requirement comes from Neb. Rev. Stat. Section 84 1412 3 which states, TLHE body shall require any member of the public desiring to address the body to identify himself or herself, including an address and the name of any organization represented by such person unless the SS underscore requirement is waived to protect the security of the individual. Hallman. Ma'am, excuse me, ma'am. Wait GTAGY. The video shows Ms. Adamson to abit her address when requested. She nevertheless continued to speak for her phone. Dr. Hallman informed Ms. Adar. For playing an audio recording on she needed to give her own public. Hallman. Are you a part of the Omaha Public Schools? Asterisk. MSON did not do so and continued to of the public to speak at meetings of the public to play comment and not play the audio recording. Play the recording. Policy number 8346 permits and give public comment. It does not permit MER. EW, MD podium due to the content of her speech but rather because she did not provide her. Fifth regard to Mr. Riddle, he was not allowed to speak because he refused to state his address. Neb. Rev. Stat. Section 84 1412 3 as well as policy number 8346 requires speakers to give their address. Mr. Riddle refused to do so and did not request a waiver. Adamson. Yes. Asterisk. Hallman. Okay, thank you. Asterisk. Adamson. Taught in ops also, 36 years. So, does my time start now? Asterisk. Hallman. Yes, you may continue. Thank you. January 6, 2022. Ops itself systematically suppressing public participation and access to records, silencing and retaliating against citizens who dared to question its misconduct before the board. Including attorney David Kramer sending this lie to the Attorney General's office, as well as fighting with every bit of strength that they can muster, to abuse procedurally and professionally through their backroom connections and rigged game. Laura A. Nigro. December 22, 2021 page 4. The district records its meetings and posts them to its website. 14/19/2021, meeting can be found at the following link. 2V equals YNOVO4I3FUO and list equals PLZNBR7 Junior 8 AKWXFFAXV3AEXG 45JZJ91 boy and index equals 12. The relevant portion relating to public comment commences at the 28:56 mark. Conclusion. The district's actions in this instance were simply to comply with the legislative directive that members of the public wishing to address the Board of Education provide their addresses. It was for that reason, and that reason alone, that the district asked Ms. Abramson to step away from the podium. I man direct 7 Riads % odd B tur off. Ms. Riddy. The meeting was solely the result of his refusal to step away from the podium and attempted continued engagement with the Board of Education. It should be noted that Mr. Riddle has subsequently appeared at multiple meetings of the Board of Education without further incident relating to the provision of his address. In light of the foregoing, the district asserts that there was no violation of the Nebraska Open Meetings Act and respectfully requests that the complaints be dismissed. If you should have any questions with respect to this response, please don't hesitate to contact me. Can be reached at my direct dial number, 402-636-8306 or via email at dkramer@bertholm.com. Thank you in advance for your consideration. Very truly yours. The Eighth Circuit and Nebraska courts repeatedly abdicating their duty to confront the overwhelming evidence of official lawlessness, instead contriving an endless stream of unevenly assessed and often incorrect procedural devices to bury petitioners' claims, while simultaneously claiming no ability to look at the evidence pasted in the initial pleadings for all to see. Incontrovertible evidence of bank fraud and forgery disregarded without so much as a hearing, as state and federal agencies turned a blind eye to corruption. And loan document. Sent mo batu amzant o. In flungu jos flental mogags in rritc, ol romi. Zins o poimesis hantonane. Traxon mo os 5 s5 ss $ss. 3 is sss. S $3 s inserate 2p propylate crozio 1 rimhe sn 0t6l00 dmmbehs. Krodner norso akan rum. 00t1 ryu saintwer vea lnbmevmi. Omalmupel fos urg sorens underscore kodarawas e8r and ualo a heat 3 cent cxplspatian, yo 3 or o. Ia e ishi dlpegmonls 3 btu. Quote dot. Hinu beyond dectumdi bank ngt winadoa past 7 years. And boi guzasi lorios vpon o jedla ot dod. 4. B. And. 0. Rechy. Hash. And. 3017 Foudamonted Nhi 7YEO 400 Section 98 Asiwemnario oi 82 inches ESY on ANY, EHSN Verrechtener, Transfer of EYE of WMW Usushlands N Untau Re Rans L Li 3 Rossio Bombs Cons, Psi. Equals Motigago, Tenansial Agaden, TND, Otoau Gamelka. 1AL Sroviden Det, versus X Weeksting DRTE, J9EM Mon X Dar SWLAR Gier, FHA 06 VIT 3 pounds un NM Dar, 2Y, Ard Ray 21 CEN at Essen. OIY plus MBTOT. PYT, W equals Origage, H, ZN, Lo.grm a T Shran. O5A2U Ovientans TN Pri N Lanoimi, Civid D2 Grur O Sipa Wanlisans. 33 Enipant GF 199 Deepwi Init Consia. 001, Arc Yowa Cosmans OT Encourses or ASO 50. EO3 Pis EK a 3 ant. Du Uladen 3 Vapropecti 3 cents Yul Primati Rostrans. IETYAT, Convils question I Kala. Fuhas an AERRE 0 OSRA 1T0 PFHE Fast EO. ROROOCO. EHOROREER. L3. I. 8 UNCWEN. P. M0O. ROR. And. ORCRIRE. OLB, type of ROP 90TUYGTY Oradisons 00 1PR Kokond H Omo 8H07 Wit R Muro 57 Z2DI How Tig Yao OLV 10FHW Hori by your ELT 3 Etarem Smata ISSSEAS SUCLEIIONAYNBERPAS and UHOES at Chanel Omegagand M Srozea. Oh. These are not isolated bad acts, but interlocking gears in a conspiracy against the public trust. What emerges from petitioners' forensic reconstruction is a portrait of a system in crisis, a meltdown of the basic norms and safeguards of civilized self-rule. This case thus poses a singular challenge for Nebraska's High Court, whether it will at long last draw a line against the tide of lawlessness or allow the last levees of constitutional order to be swept away. Whether the judiciary will reclaim its role as a check on official impunity or invite its own marginalization in a devolution toward autocracy. These stakes transcend any one litigant or controversy. At its core, this petition presents an MRI of our body politic, exposing cancers that have been allowed to metastasize in the darkness. Piece by piece, it reveals a machinery of government captured by special interests, disdainful of public scrutiny, and increasingly antagonistic toward the most basic ideals of democratic accountability. And undergirding it all is a spreading rot within our civic culture, a slow-motion unraveling of the rule of law, driven by a toxic symbiosis of official arrogance and public apathy. A sense that the fix is in, that Lady Justice's scales are just props in an elaborate charade. Petitioner comes before this court as the canary in that coal mine, the ripple that portends a coming tsunami. For years, he has been caught in a whirlpool of Kafkaesque abuse, railroaded by star chamber commissions, frozen out of public meetings, smeared and stonewalled at every turn as he tried to bring officials to account. Most disturbing of all is the pattern of collective amnesia and gaslighting that greets his efforts, the blithe reversals and buck passing from one complicit entity to the next. The UPL disclaims all knowledge of its own disciplinary complaint, even as it brandishes the complaint as a sword. The AG's office touts case law on child welfare while conspiring with ops to conceal blatant Open Meetings Act breaches. The courts, confronted with smoking gun evidence of abuse after abuse, avert their eyes, taking refuge in an increasingly threadbare and opportunistic proceduralism. Through it all, the circle of impunity tightens, each exposed misdeed begetting another convoluted stratagem of denial and deflection. A paranoid observer might see the hidden hand of some central puppetmaster behind the scenes, orchestrating the parts in an elaborate pantomime. But as this petition makes abundantly clear, the truth is at once more prosaic and more chilling. What Petitioner has unearthed is not some Baroque conspiracy, but a dense network of petty fiefdoms and bureaucratic power centers, each jealously guarding its piece of turf in our decaying republic. The AG's office, OPS, the UPL, they are not arms of some shadowy cabal, but independent redoubts of entrenched institutional power, bound together by cronyism, incestuous ties, and a common interest in evading democratic control. The result is a governing class that operates as a law unto itself, insulated from grassroots pressure by layer upon layer of mazes and moats. And the longer this closed loop of elite back-scratching persists, the more atrophied our corrective mechanisms become. Scandal, the salutary shaming power of exposure, loses its sting as the outrage and outrageousness is turned back on the accuser. Meanwhile, a culture of collective resignation sets in among a citizenry conditioned to expect the worst and hope for little better. If all this sounds familiar, it should. The dysfunction chronicled in this petition is just a microcosm of the crisis of elite impunity that is rotting out the foundations of public trust across America. The details may vary, but the core predicament is the same: an epidemic collapse of accountability as the normal feedback loops of Republican politics break down. The implications reach far beyond Nebraska, to the very sustainability of the American experiment in ordered liberty. For if the rule of law is to be more than parchment, if our Constitution is to retain its meaning as the supreme check on arbitrary rule, there must remain some mechanism, some civic circuit breaker to hold the powerful to popular account when the ordinary channels of politics fail. Historically, this role of last resort of republic defender has fallen to the judiciary. Time and again at the hinge points of our nation's journey, far-sighted courts have stepped forward to defend democracy's core as political elites conspired against it. From Marbury's besting of constitutional review to the Warren era's perfection of the writ of liberty, the finest hours of the American bench have come when judges looked beyond transient electoral majorities to vindicate the deeper social contract between ruler and ruled. Now this court is called to that fateful office, conscripted by the extremity of our civic crisis to serve as democracy's last line of defense. The question, stark and unavoidable, is whether Nebraska's High Court will rise to the challenge, or preside over a long twilight of constitutional rot. That question carries a weight of obligation far beyond the norm for a case of this type. For you see, Justin Riddle's struggle is not simply his own, it is that of every citizen betrayed by the false idols of hollow self-government, every patriot sickened by the stench of endemic self-dealing wafting from our corridors of power. In this sense, Petitioner is less litigant than Cassandra, the far-sighted prophet cursed to foresee the unraveling of our civic fabric but powerless on his own to arrest it. Having exhausted all other recourse, he turns at last to this tribunal, to sound the alarm and force a reckoning while the chance for peaceful self-correction still remains. The record he has assembled to guide that reckoning is as meticulous as it is damning. With the methodical precision of a forensic scientist reconstructing a crime scene, Petitioner has laid out, piece by interlocking piece, the architecture of Nebraska's unfolding democratic collapse. He has shown how a kleptocratic fusion of public and private power lubricated by a revolving door of institutional players moving between perches in the machinery of soft corruption has spawned a faux meritocratic class increasingly contemptuous of the public it supposedly serves. How that class sustains its rule through insular networks of privilege and protection, stifling dissent by press ganging every organ of government into a makeshift Praetorian Guard. He has documented the weaponization of procedure and the erosion of informal norms, the thousand cuts by which substantive justice is bled dry on a bed of legalisms. How the law, administered by guild loyalists and gamed by an entrenched bar, becomes complicit in its own subversion, a constitutional charade played out in a haze of mystification that anesthetizes the public to the seizure of popular sovereignty happening just off stage. The evidence of this democratic decompensation is so copious, so painstakingly catalogued in the pages that follow, as to present this court with an inexorable mandate. No fair reading of the record can sustain the fantasy that this rot is cabined to a single bad actor, or even a rogue phalanx. What Petitioner has revealed is systemic dysfunction, a spreading decay that implicates our entire mode of governance and demands a commensurately systemic correction. Of course, Petitioner himself is under no illusions about the forces arrayed against that correction, or the enormity of will required to accomplish it. He is intimately acquainted with the most insidious tricks in the establishment's defensive playbook, the subtle condescensions, the blizzards of legalese, the strategic deployments of the passive voice to launder away agency. Even now, he can hear the mental gears whirring, the rhetorical assembly lines springing to life, as a cornered power structure gears up to discredit and deflect. Any citizen who threatens business as usual must be an erratic paranoiac, a cook in a tinfoil hat. The quotidian abuse of the law is a conspiracy theory, the procedural checkmate, a principled adherence to neutral norms. Move along, nothing to see here. Such is the Baroque scaffolding of rationalization by which a guild polices its own, transmuting constitutional dereliction into professional duty. Confronted by a metastatic rot, the temptation for any institution is to deny, minimize, and compartmentalize to avoid the pain of reform by numbing itself to the crisis. But this is precisely the mentality that must now be overridden if the rule of law is to endure the seductive delusion that our civic degeneration is just an optical illusion, a matter of optics and angles that steadier hands can finesse away. For as this case makes excruciatingly clear, we are long past the stage of easy fixes and painless corrections. The tumor in our body politic has burrowed too deep, sprawled too far. Only radical surgery can now save the patient. What's required, in short, is a revolution not of blood, but of ethos. A wholesale reconception of the role of the judiciary in our unraveling republic, wherein a long slumbering power is roused to world historical purpose, and all the hydraulic pressures of a sclerotic system are brought to bear on bending the arc of our civic trajectory. Nothing less will do if government by the people is to be ripped from the jaws of a new feudalism. For let us be clear, what is at stake in cases like petitioners is the very possibility of popular sovereignty in an age of metastatic special interests. It is the question of whether our constitution will be a covenant or a parchment barrier, our democracy a lived reality or a carefully preserved diorama. And it is a question, at bottom, of whether we as a society will muster the grit and gumption to confront the most dire threats to our way of life, or succumb to the inertia and anomie of a post-republican future. This court, of course, cannot resolve such immense civilizational tensions on its own, no single tribunal could. But it can model, at this hinge of history, what it looks like for a constitutional watchman to take up the torch and sound the alarm. It can demonstrate, through its response to petitioner's plea, how an institution summons the moral imagination to meet a singular challenge, and repurpose itself as an engine of democratic renewal. The pages that follow provide both the impetus and the blueprint for that renewal. In searing detail, they map the subterranean circuitry of Nebraska's burgeoning autocracy, the dark money conduits, the backroom machinations, the subtle state capture behind the Potemkin villages of representative governance. But they also shine a light on the critical nodes where this architecture of impunity is most vulnerable, the choke points where a sufficiently bold court could galvanize popular resistance and begin to reverse the tide. From the UPL's bald-faced traducing of due process to the AG's open breaches of his investigative duties to the judiciary's own shrinking from its constitutional station, petitioner has surfaced a target-rich environment for any tribunal serious about constitutional triage. The only question is whether this court will find the wherewithal to take those shots to forge, in the crucible of this case, a template for the judiciary's resurgence. As a bulwark of popular sovereignty, it is a heavy burden, but not an unfamiliar one. Indeed, in a sense, it is the burden every high court bears at the hinge points of a republic's journey, when the precise balance of forces shaping its trajectory, towards self-correction or accelerating decay hangs in the balance. In such moments, the case at bar is always both an end in itself and a means to a larger societal inflection. The litigants are stand-ins, the fact pattern a synecdoche for the moral challenges of an era. What's really on trial is not any one transgression, but a system's capacity to hold itself to account, to regenerate from within the antibodies of self-rule. So it ones with petitioner's struggle, which at once encompasses and transcends his personal odyssey through the labyrinth of Nebraska's fraying civic fabric. In telling his story, in laying out the manifold threads of official malfeasance that ensnare him, he is really relating a parable of American democracy at the crossroads, a dispatch from the smoldering frontiers of a republic in twilight. The question this court must now decide is what answer we as a people will send back from those frontiers. Will we succumb to the entropy of a system sliding into autocracy, or will we summon the civic will to arrest that slide and reclaim self-government? Will we accept endemic lawlessness as the new normal, or will we demand a new birth of constitutional liberty? For petitioner, for the judiciary, and for Nebraska as a whole, the fateful hour of that choice is at hand. This pleading an autopsy of our democratic decay wrapped in an SOS from its depths leaves no room for equivocation or half measures. It demands of this court nothing less than what the times demand of us all, a spirit of moral clarity to match our gathering civic storm. That means seeing petitioner's plight for what it is, not some idiosyncratic outlier, but a harrowing harbinger of a system coming unglued. It means treating the monstrous record of abuse he has assembled as an MRI of our body politic, a diagnostic flare illuminating patterns of metastasis that can no longer be ignored. Most of all, it means rising to the challenge of this moment with all the moral and intellectual resources at this court's command. To meet petitioner's cri de coeur with an answering trumpet blast of full-throated reassertion of government of laws, and not of men, as the supreme law of Nebraska. Nothing less will do if the rule of law is to prevail in this case, in this state, and in the anguished annals of the American experiment. We cannot go on in a republic half broken, with a constitution half shredded. Sooner or later, the center must find a way to hold against the entropic forces threatening to tear it asunder. Petitioner has done all one citizen can possibly do to light the path towards that civic reckoning. Now he stands before Nebraska's highest court, asking it to pick up that torch and carry it forward to be the stone that starts an avalanche, the spark that catalyzes a democratic renaissance. May this court prove equal to that epical charge. For Justin Riddle's sake, and for the future of our imperiled republic. A generation of Nebraskans yet unborn, indeed, a nation hanging in the balance will judge us by what follows. With that, petitioner turns to the sordid specifics of the case that compels this court's immediate intervention, a case that, if left unchecked, will be the canary in the coal mine for a system of justice in terminal decay. This journey has largely been fought alone, until late summer 2024, when plaintiff's appearance in front of this very tribunal became the #1 result in YouTube for pro se wins, self-represented wins, and over a dozen other search terms. Garnering several thousand views a day, it has produced countless emails, comments, and an informed public, now aware that there is hope for justice when an unbiased panel is involved. Consequently, thousands of people across the United States, and in fact the world, look again for this great tribunal to shine where all others have not just failed, but actively conspired with and became the most abusive of abusers. NLT, real-time. Some 4,030 views. October 15, 2024, 2 p.m., 1:24. NLT, views. 48 hours ago. Since published first 24H7D28D. Top traffic sources 123.0K. Browse features SILE ISE CLE RV 1E1S YouTube search. Other YouTube features 101. BZNCENS. Director unknown 22 PI equals 11 PY. Dashboard content FLEN community. Statement of jurisdiction. This court has original jurisdiction to issue writs of mandamus, prohibition, and supervisory control pursuant to Article 5, Section 2 of the Nebraska Constitution and Neb. Rev. Stat. Section 24 to 204. The extraordinary nature of this case necessitates the exercise of this court's supervisory powers for the following reasons. 1. Egregious violation of due process. The Commission on Unauthorized Practice of Law's refusal to provide petitioner with the complaint against him represents a fundamental breach of due process that cannot be remedied through ordinary appellate channels. This court's immediate intervention is necessary to prevent irreparable harm to petitioner's constitutional rights. 2. Systemic failure of lower courts. As detailed in this petition, multiple lower courts have consistently failed to address clear and compelling evidence of official misconduct. This pattern of judicial abdication threatens the integrity of Nebraska's entire legal system and requires correction by this court. The fact that these failures have occurred across both state and federal forums only underscores the necessity of a unified and comprehensive response from Nebraska's highest court. Plaintiff is fully aware of jurisdictional differences, and is using both local and federal cases he has been forced to participate in as evidence of extreme abuse of process against pro se litigants from the legal system in general. 3. Issues of exceptional public importance. This case implicates core principles of democratic governance, including Freedom of Information Act, transparency, accountability, and the rule of law. The questions presented here transcend the interests of the immediate parties and touch upon the fundamental relationship between citizens and their government. The pervasive and cross-cutting nature of the misconduct at issue makes it imperative that this court intervene to safeguard the rights of all Nebraskans. 4. Absence of alternative remedies. Petitioner has exhausted all available administrative and legal remedies without obtaining meaningful redress. The failure of federal and local courts, the Nebraska Attorney General's Office, the Nebraska Ombudsman's Office and the school district to address these issues only confirms the absence of any adequate alternative forum for the vindication of petitioner's rights. Only this court's exercise of its extraordinary writ powers can provide the comprehensive relief necessary to address the systemic issues identified in this petition. There's simply no alternative way for Mr. Riddle to address and correct the lies, when the attorney for the state, the largest subdivision in the state ops, the Capitol Police, the Ombudsman's Overwatch Department and all the attorneys, are swapping spit and partners in the back of an El Camino. 5. Urgent need for clarification of law. The lower court's handling of this and related cases has created significant confusion regarding the proper application of Nebraska's public records laws, open meetings requirements, and due process guarantees. This court's guidance is essential to ensure uniform and correct application of these critical legal principles across all Nebraska courts, regardless of whether an individual case arises in state or federal jurisdiction. When the government is allowed to change reality through stonewalling and obfuscation, the government is an entity without protection. Parties. Petitioner. Justin Riddle is a citizen of Nebraska residing in Omaha. He is a small business owner, parent of school-aged children, and active participant in civic affairs. Over the past decade, Mr. Riddle has engaged in persistent efforts to expose and correct misconduct by various state entities, acting pro se in multiple legal and administrative proceedings. Respondents. 1. The Nebraska Commission on Unauthorized Practice of Law, a body established by the Nebraska Supreme Court to investigate and prosecute instances of unauthorized practice of law. The Commission is the primary actor in the immediate due process violations alleged in this petition. 2. The Nebraska Attorney General's Office, the chief legal officer of the state, responsible for investigating violations of state law and representing the public interest. The AG's office is implicated in the misrepresentation of facts related to Omaha Public Schools Board meetings and the subsequent refusal to correct false information. It is noteworthy that the current AG's administration is different from the one involved in the initial ops investigation and the prior Charter West Bank matter. Yet the office's pattern of misconduct persists across administrations, suggesting a deeper institutional rot. 3. Omaha Public Schools, the public school district serving Omaha, Nebraska. Ops 1's alleged to have violated open meetings laws, engaged in viewpoint discrimination, and obstructed public records requests. 4. The 8th Circuit Court of Appeals, named as a respondent due to its alleged failure to properly consider evidence and apply relevant law in petitioner's appeals. Although this is a federal court, its inclusion is essential to illustrate the systemic nature of the denials of due process and fair hearings across jurisdictional boundaries. Factual background. 1. Hearing scheduling issues. The Douglas County District Court's failure to promptly schedule a hearing on petitioner's emergency motion, as required by Neb. Rev. Stat. Section 84 to 712.032, is further evidence of the judiciary's complicity in obstructing his access to records and denying him due process. Despite the clear statutory mandate that petitions under the Public Records Law shall take precedence on the trial docket over all other cases and shall be assigned for hearing, trial, or argument at the earliest practicable date and expedited in every way, the court arbitrarily delayed setting a hearing on petitioner's motion until nearly 40 days after it was filed. This unwarranted deferral impermissibly aids respondents' efforts to obstruct petitioners' access to public information through dilatory tactics, and evidences the court's disregard for the legislature's unambiguous intent that such matters be heard, at the earliest practical date. 2. UPL Commission's due process violations. The Commission on Unauthorized Practice of Law initiated disciplinary proceedings against petitioner without providing him a copy of the complaint or any details of the allegations against him. Petitioner made multiple good faith attempts to obtain this information, including written requests sent to the Commission, telephone calls to the Commission's office, in-person visits to the Commission's office. Despite petitioner's diligence, the Commission has unlawfully refused to provide the complaint, claiming that confidentiality rules prevent disclosure. This Kafkaesque justification flagrantly violates fundamental due process rights guaranteed by the Nebraska and U.S. constitutions. 3. Attorney General's Office misconduct. The Nebraska Attorney General's Office conducted a biased and incomplete investigation into complaints about Omaha Public Schools board meetings. The AG's final determination contained demonstrably false statements minimizing OPS misconduct. Specifically, the AG falsely claimed that petitioner's mother, Cheryl Adamson, was removed from a meeting for refusing to give her address, when video evidence clearly shows she was silenced for attempting to play an audio recording critical of OPS. The AG failed to interview key witnesses, including petitioner and his mother, the actual victims of the misconduct. The AG exclusively relied on information provided by OPS officials, failing to conduct an independent review of the pertinent records. When confronted with video evidence conclusively debunking the AG's findings, the office refused to correct the false statements, stonewalled public records requests, retaliated against petitioner with a trespass warning when he visited the Capitol to file complaints. It bears emphasizing that this misconduct occurred under a new AG administration, different from the one responsible for the initial sham investigation. The fact that the office's posture remained unchanged despite the leadership transition points to entrenched institutional corruption rather than isolated missteps. 4. Ombudsman's Office complicity. Nebraska's Public Counsel, commonly known as the Ombudsman's Office, is supposed to serve as an independent watchdog over state agencies. But in this case, it has been complicit in the very misconduct it is charged with policing. Specifically, the Ombudsman's Office has refused to investigate petitioner's well-documented complaints against OPS and the AG, blocked petitioner from even entering its physical office in retaliation for his activism, exhibited a pattern of reflexively deferring to and covering for the agencies it is supposed to oversee, both in this matter and petitioner's prior complaints regarding Charter West Bank. This abdication by the state's top government accountability office confirms the sweeping nature of the breakdown in checks and balances. When the watchmen are in bed with the watched, the entire system of public integrity crumbles. 5. Omaha Public Schools open meetings violations and cover-up. Omaha Public Schools and its board engaged in a pattern of silencing and retaliating against speakers at public meetings, violating their free speech and public participation rights. These include shutting off the microphone of Cheryl Adamson when she attempted to play an audio recording critical of OPS, having petitioner removed by security when he tried to assist his mother with the recording, arbitrarily and inconsistently enforcing speaker rules to suppress dissenting viewpoints. To cover up these violations, OPS misrepresented the reasons for silencing speakers to the AG's office, defied public records requests seeking further information about the incidents, improperly sought a protection order against petitioner to retaliate against his activism and intimidate him from participating in future meetings. 6. Documented bank fraud. In 2019, petitioner discovered irrefutable evidence that Charter West Bank had fraudulently altered his loan documents, adding a checkmark claiming he had past due child support obligations without his knowledge or consent. These alterations negatively impacted his finances, credit, and reputation. Petitioner provided this evidence to the Nebraska Department of Banking and Finance, the Federal Reserve Bank of Kansas City, the Consumer Financial Protection Bureau, the Nebraska Attorney General's Office, the Nebraska Ombudsman's Office, the Douglas County District Court in a lawsuit against Charter West. Despite the clear and compelling proof of fraud, each of these entities failed to take any meaningful action to investigate or rectify the bank's misconduct. The court summarily dismissed petitioner's claims without even considering the documentary evidence. The Ombudsman's Office was likewise indifferent to petitioner's complaints about Charter West, refusing to probe the bank's actions or assist him in obtaining relief. This across-the-board stonewalling by regulatory agencies and courts, in the face of smoking gun evidence of financial institution fraud, epitomizes the rigged game petitioner has been forced to play at every stage of his Kafkaesque journey. Procedural history. 1. Charter West Bank litigation. Petitioner filed suit against Charter West in Douglas County District Court, presenting irrefutable evidence that the bank had altered his loan documents. The district court dismissed the case without holding a hearing or addressing the proof of fraud. On appeal, the Nebraska Court of Appeals affirmed the dismissal in a one-sentence opinion that failed to grapple with the merits of petitioner's claims or the substantial evidence of misconduct. 2. OPS Public Records lawsuit. In August 2024, petitioner filed a complaint in Douglas County District Court against OPS for violations of the Nebraska Public Records Act. Despite providing video evidence and official documents exposing OPS's pattern of wrongdoing, the district court dismissed the case on opaque jurisdictional grounds without reaching the substance of the claims. Petitioner immediately filed an emergency motion to reconsider, which included further evidence, but was delayed and denied meaningful review due to apparent bias on the part of Judge Dwayne Doherty. On October 1, 2024, the court held a hearing on petitioner's emergency motion and OPS's untimely motion to dismiss. Judge Shelley Stratman repeatedly refused to consider petitioner's evidence, insisting on phantom verification requirements not found in the public records law. The judge entertained and granted OPS's motion to dismiss despite it being filed just one day before the hearing, depriving petitioner of adequate notice and opportunity to respond. She also disregarded the statute's mandate that each party request their own hearing, instead allowing OPS to hijack petitioner's properly noticed hearing with their last-minute motion. This conduct denied petitioner a fair opportunity to be heard and violated basic norms of procedural due process. 3. Motion to recuse Judge Doherty. Since refiling after the October 1 hearing, Judge Vaughn, who was randomly assigned the case, has recused himself because of an apparent conflict of interest due to a family member working for Omaha Public Schools. It was then reassigned to Judge Doherty. Petitioner filed a motion to recuse Judge Dwayne Doherty based on his demonstrated bias and disregard for statutory scheduling priorities in an earlier case involving the same parties, Hallman v. Riddle, as well as the current matter. Judge Doherty's conduct in refusing to promptly set a hearing on petitioner's emergency motion, as required by law, and his history of prejudice against petitioner, created an intolerable appearance of partiality and cast doubt on his fitness to oversee the case. The fact that this recusal request has yet to be accepted by Judge Doherty underscores the structural conflicts of interest built into the judicial oversight process. 4. Federal civil rights action. Concurrently with his state court efforts, petitioner brought a federal civil rights lawsuit against OPS in the U.S. District Court for the District of Nebraska. The district court dismissed the case in a conclusory order that failed to address the extensive evidence of constitutional violations. On appeal to the Eighth Circuit, petitioner presented additional documentary proof of OPS's misconduct and the AG's complicity, but the court summarily affirmed the dismissal without analysis in a one-sentence opinion. Argument. Evidence of systemic bias against pro se litigants. The obstacles and double standards petitioner has faced as a pro se plaintiff are a critical factor in the breakdown of accountability documented throughout this petition. The pattern of pervasive institutional bias against citizens representing themselves insulates public officials from the scrutiny of all but the most determined and legally sophisticated watchdogs. Petitioner's attempts to navigate the complexities of the judicial system in good faith have been met at every turn by a toxic combination of hyper-technical nitpicking, flagrant disregard for his procedural and substantive rights, and blatant favoritism toward the government entities he seeks to hold accountable. The court's unyielding elevation of form over substance and imposing crippling technical barriers to access based on phantom rules presents an insurmountable hurdle for all but the most privileged pro se litigants. This Kafkaesque labyrinth makes a mockery of the law's promise of open courts and self-representation as a check on official abuse. Instead, it reduces those guarantees to a cynical mirage, tantalizingly dangled but endlessly receding in a fog of arbitrary hoops and gotcha gains. The result is a two-tiered system of justice, where deep-pocketed interests flit effortlessly between star chambers while the downtrodden masses founder in procedural tar pits. If the judiciary is to retain any claim to moral legitimacy, it must act decisively to dismantle this rigged regime. The right of citizens to petition for redress of grievances against their government, the right at the very heart of petitioners' long struggle, cannot be made to hinge on mastery of an arcane and ever-shifting code decipherable only by the initiated. Due process must be more than an empty incantation mouthed over an increasingly autocratic reality. The first step in that regeneration is to return to first principles in pro se cases implicating government misconduct, to liberally construe pleadings, minimize procedural pitfalls, and put substance firmly ahead of form. This case presents an opportunity for the court to model an evolved pro se standard rooted in the recognition that procedural complexities must sometimes yield to the imperatives of constitutional order. Such an evolution is long overdue if open courts and self-representation are to be more than dead letters. The one-two punch of exclusionary procedure and judicial bias has already all but sealed off the courts as an avenue of popular accountability. Without a profound rethinking, the day is not far off when the people's last peaceful means of civic redress will be lost. Petitioner, who has given so much of himself to pull the legal system back from that brink, asks only that he not be punished for his refusal to give up on the Constitution's covenant. The court can start to make good on that covenant by meeting petitioner on the level field of substantive justice, rather than the rigged terrain of procedural gamesmanship. 2. The UPL's refusal to provide the complaint violates due process. The bedrock principle of due process, enshrined in the U.S. and Nebraska constitutions, is the right to notice and a meaningful opportunity to be heard before the government deprives a person of liberty or property. The UPL Commission's refusal to provide petitioner with a copy of the complaint against him, or even apprise him of the factual basis for the charges, makes a mockery of this most basic guarantee. This court has long recognized that due process requires timely and adequate notice of the charges in attorney disciplinary proceedings. State ex rel. NSBAV. Dineen, 235 Neb. 363, 455 NW2D 178 1990. The court has also held that the notice must be sufficiently specific to allow the preparation of a defense. State ex rel. NSBAV. Rubicek, 225 Neb. 509, 406 NW2D 644, 1987. The UPL Commission's actions here fail to meet even the most minimal standards of constitutional notice. By initiating disciplinary proceedings without providing the complaint, the Commission has placed petitioner in the impossible position of defending against unknown accusations based on undisclosed evidence. This is the very definition of a Star Chamber proceeding anathema to a system of ordered liberty. Moreover, the Commission's vague allusion to confidentiality concerns is wholly insufficient to overcome petitioner's due process rights. While the court has recognized limited exceptions to full disclosure in certain circumstances, see State ex rel. NSBAV. Miller, 258 Neb. 181, 602 NW2D 486 1999. Those exceptions are narrow and cannot justify the complete denial of notice here. If the Commission truly believes some portion of the complaint requires redaction or protection, it must still provide petitioner with the substance of the allegations and a meaningful chance to respond. Its current stance of blanket secrecy is legally indefensible and practically unworkable, a recipe for abuse that offends the very notion of regularity in governmental action. This court should therefore issue a writ of mandamus directing the Commission to immediately provide petitioner with a copy of the complaint, including any supporting evidence or documents. To the extent the Commission believes specific, narrowly tailored redactions are necessary, it must justify them to this court in an accompanying motion, but the default must be disclosure, not concealment, if due process is to have any meaning. ITI. The AG's sham investigation warrants judicial intervention. The Attorney General's farcical investigation into OPS's open meetings violations is a textbook example of a watchdog agency captured and corrupted by the very interests it is supposed to police. From start to finish, the AG's office acted not as a neutral fact finder but as an apologist and co-conspirator in OPS's misconduct, contorting the truth to fit a predetermined narrative of absolving its fellow state actors. The most egregious manifestation of this dereliction of duty was the AG's formal report, which whitewashed clear evidence of OPS's silencing of speakers and made materially false statements about petitioner and his mother that were squarely contradicted by the meeting videos. These misrepresentations were no mere mistake, they were deliberate falsehoods, designed to provide cover for OPS's unlawful actions and discredit the victims who dared to speak out. When presented with irrefutable video proof debunking its conclusions, the AG's office responded in the most telling way possible, not with apologies and a commitment to correct the record, but with stonewalling, foot-dragging, and outright retaliation against petitioner for bringing the issues to light. This is the modus operandi of a political hack, not a constitutional officer, a shameful abdication that cries out for judicial oversight. Crucially, this misconduct cannot be dismissed as the work of a few rogue actors or a single bad administration. The fact that the AG's office maintained its obstructionist posture across leadership transitions from the initial sham investigation to the current regime's refusal to correct the record points to a deeper institutional malady. It suggests a culture of impunity and collusion with other state power centers that is antithetical to the office's core mission of ensuring governmental accountability. This court has not hesitated to intervene where deficient investigations by other branches of government threaten the integrity of our legal system. In State ex rel. Shepard vs. Neb. Equal opposite. Com. 251 Neb. 517, 557 NW2D 684 1997, the court issued a writ of mandamus compelling the NEOC to conduct a proper investigation where it had failed to follow its own procedures and statutory duties. The court emphasized that abdication of a statutory duty by an agency of state government is no less serious than abdication of duty by other governmental bodies. ID. At 528, 557 NW2D at 692. The same principle applies here with even greater force, given the AG's role as the state's chief legal officer and the constitutional magnitude of the rights at stake. By refusing to conduct a fair and impartial inquiry, and instead actively perpetuating falsehoods to protect ops, the AG's office failed its basic obligations to the citizens it serves and made a mockery of its oversight mandate. This court should therefore issue a writ of mandamus directing the AG to withdraw its report, publicly correct its false statements, and initiate a proper investigation into OPS's actions that includes interviewing petitioner, his mother, and other key witnesses, and examining all relevant evidence. Anything less would reward the AG's duplicity and send a dangerous message that government agencies can trample citizens' rights with impunity. IV. The Ombudsman's complicity subverts its watchdog role. Just as troubling as the AG's misconduct is the Nebraska Ombudsman's office's complicity in the very abuses it is supposed to check. As the state's top independent watchdog over government agencies, the Public Counsel is entrusted with the vital task of ensuring public integrity and exposing official wrongdoing. But in this case, it has utterly abdicated that duty, instead serving as an enabler and accessory to the AG's and OPS's misconduct. The Ombudsman's sins are ones of both omission and commission. It has refused to investigate petitioners' meticulously documented complaints, in flagrant breach of its statutory charge. Worse, it has overtly retaliated against him for his whistleblowing, going so far as to physically block him from its offices and align itself with the retaliatory efforts of other agencies. This dereliction represents a complete inversion of the Ombudsman's intended role. Rather than proactively ferreting out governmental abuse and championing citizens' rights, the office has chosen to run interference for the powerful against the powerless. It has treated petitioners' exhaustively substantiated claims as unwelcome inconveniences to be swept under the rug, rather than vital alerts to be heeded and pursued. Nor can this failure be isolated to the public records and open meetings context. As the background section details, petitioner has had strikingly similar experiences with the Ombudsman's office in attempting to expose Charter West Bank's fraud and forgery. There too, he was met with an impenetrable wall of institutional indifference and deflection, an agency too compromised or cowed to discharge its basic oversight duties. The Ombudsman's wholesale capture by the entities it regulates is thus an indispensable part of the mosaic of UN accountability chronicled in this petition. It reveals an insular and self-protective statehouse culture, in which nominally independent agencies operate as de facto satellites of the executive, covering for sister departments, misdeeds out of a misplaced sense of bureaucratic loyalty. In such an incestuous environment, the very concept of external checks swiftly breaks down. Misconduct that should set off alarm bells instead gets smothered by an unspoken code of silence, a wink and nod solidarity among agency heads. And citizens who try to sound those alarms through proper channels find themselves ensnared in a rigged and Kafkaesque system, one that takes umbrage at being challenged while refusing to police itself. To restore public faith in the integrity of state government, this court must forcefully disrupt that cozy and collusive dynamic. Specifically, it should issue a supervisory writ directing the Ombudsman's office to reverse any retaliatory measures taken against petitioner, such as trespass notices or office access restrictions. Open immediate investigations into his complaints regarding OPS, the AG, and Charter West Bank, with findings to be reported to this court within 60 days. Adopt enhanced public transparency measures, including posting all citizen complaints and investigative reports online and holding quarterly town halls to discuss its work. More broadly, this court should use its moral authority to set a new tone of openness and accountability for all state watchdog agencies. It should make clear that a closed ranks, see no evil, approach to external oversight is incompatible with the constitutional order, and that public integrity entities will be held rigorously to their statutory mandates. Only by renewing these agencies' sense of mission and fear of public scrutiny can the court begin to break the cycles of back-scratching and groupthink that have corrupted them. The breakdown of checks and balances requires this court's intervention. The judiciary's wholesale failure to address the overwhelming evidence of official misconduct in this case is not simply an error of judgment, it is a fundamental breach of the court's duty to act as a check on the political branches and uphold the rule of law. From the Douglas County District Court to the Eighth Circuit Court of Appeals, the response to petitioners' meticulous documentation of wrongdoing has been a shameful display of willful blindness and complicity in the cover-up. The fact that this failure spans both federal and state courts only underscores the depth and pervasiveness of the rot. It is a sign that the usual guardrails of judicial independence and integrity have broken down, leaving citizens defenseless against even the most flagrant abuses of power. When judges at every level are unwilling to confront clear evidence of governmental misconduct, and instead go out of their way to shield offenders from accountability, the basic compact of constitutional governance begins to unravel. This court is the last line of defense against that unraveling. As the ultimate arbiter of state law and the final repository of the public's trust in Nebraska's justice system, it has a unique obligation to intervene when the normal channels of judicial review have failed so spectacularly. That obligation takes on a special urgency in a case like this, where the stakes transcend any one person's grievance and implicate the very survival of checks and balances. The court need look no further than its own precedent to find ample justification, and indeed, an affirmative duty to step in. Just last year, in State ex rel. Wagner vs. Evnen, 312 Neb. 142, 978 NW2D 337 2022, the court issued a writ of mandamus to block an initiative petition that would have eliminated political accountability for the Attorney General and other constitutional officers. In so doing, it reaffirmed its authority and responsibility to safeguard the structural integrity of state government against confusion, deception, and frustration of the will of the people. ID. At 154, 978 NW2D at 346. If ever a case cried out for the exercise of that solemn responsibility, it is this one. What petitioner has documented is not some garden-variety dispute over the finer points of administrative procedure, but a cancer on our body politic, a spreading web of official lawlessness and interbranch complicity that threatens to choke off the very possibility of democratic self-correction. Absent this court's decisive intervention, there is every reason to fear that web will metastasize until it extinguishes the last vestiges of meaningful restraint on governmental abuses. The court should therefore issue a supervisory writ directing the Douglas County District Court to vacate its prior dismissals and conduct full evidentiary hearings on petitioners' claims. It should further order the court to compel production of all relevant records from OPS and the AG's office, and to permit discovery into the full scope of their misconduct. Only by shining a bright light on the rot and giving petitioner a fair chance to prove his case can the judiciary hope to begin restoring public faith in the even-handedness of the law. But the court's remedial powers cannot end there. As the above saga illustrates, the problems petitioner has identified are not isolated bad acts but symptoms of a deeper, systemic breakdown in the legal and political accountability structures of our state. Fully resolving them will require more than piecemeal error correction, it will require a top-to-bottom rethinking of how our governmental institutions operate and interact. The district court's abdication of its duty to provide a fair hearing. Judge Stratman's conduct at the October 1, 2024 hearing on petitioner's emergency motion violated his due process rights and represents a dereliction of the judiciary's fundamental role in safeguarding citizens' access to public records. Her actions perfectly encapsulate the themes of official lawlessness and judicial complicity in the cover-up that run throughout this petition. First, Judge Stratman repeatedly refused to consider the evidence petitioner presented, insisting on phantom verification requirements not found in the public records law. This elevation of procedure over substance effectively denied petitioner a meaningful opportunity to be heard. By making the truth yield to technicality in this way, the judge rendered the hearing a hollow formality, rigged against the party seeking to expose official misconduct. Second, Judge Stratman entertained and granted the defendant's motion to dismiss despite it being filed just one day before the hearing, depriving petitioner of adequate notice and opportunity to respond. This untimely submission should have been rejected outright. Instead, the judge allowed herself to be hijacked by the defendants, sandbagging tactics, turning a blind eye to the prejudice and unfair surprise to petitioner. Third, the judge disregarded the statute's mandate that each party request their own hearing, instead allowing the defendants to commandeer petitioners properly. Noticed hearing with their last-minute motion. This denied petitioner control over his own case and the ability to frame the issues for adjudication. It also violated the clear legislative intent behind the statutory scheduling priorities. Fourth and most fundamentally, AG documents, as official government records, should be self-authenticating and presumed reliable absent specific evidence to the contrary. Judge Stratman's suggestion that petitioner needed to separately verify the AG's findings turns the normal evidentiary burden on its head. It creates an almost insurmountable hurdle for pro se litigants and concerned citizens trying to hold the government to account through the public records law. In tandem with the other failures of the judicial system documented throughout this petition, Judge Stratman's conduct at the hearing demonstrates the depth of the institutional rot afflicting Nebraska's courts. When judges are so quick to slam the courthouse doors on citizens seeking to vindicate their rights against official abuse, based on the flimsiest procedural pretexts, it represents a crisis of legitimacy for the entire justice system. The Supreme Court's intervention is urgently needed to arrest this descent into a hall of mirrors where the rule of law is endlessly subverted by a labyrinth of self-serving legalisms. 7. The need for structural reform. The interlocking nature of the breakdowns in accountability identified throughout this petition, from the UPL's stonewalling to the AG's whitewashing to the Ombudsman's complicity to the court's enablement, points to a rot that goes far beyond any one agency or branch of government. What petitioner has exposed is a diffuse crisis of integrity striking at the very heart of our constitutional system of checks and balances. The common thread running through each abuse is the weaponization of procedure and complexity to neutralize substantive checks on power. At every turn, petitioners' attempts to invoke the nominal safeguards of public accountability, from open records laws to judicial review, have been deflected by an ever-shifting array of technical barriers, gotcha games, and catch-22s. The cumulative effect is to render the tools of transparency and oversight hopelessly rigged in favor of the entrenched interests they are meant to restrain. To begin unwinding this self-perpetuating cycle of elite impunity, the court must pair its resolution of petitioners' immediate claims with a broader commitment to structural reform. It must use this case as a catalyst for a statewide reckoning with the adequacy of existing accountability mechanisms, a reckoning that puts all relevant institutions under the microscope and impels them to rediscover their constitutional purpose. As a start, this court should convene a special commission or investigative task force charged with conducting a comprehensive review of Nebraska's open government laws and their non-enforcement by the relevant state agencies and courts. This commission should be empowered to compel testimony and production of documents, and to propose concrete legislative and regulatory reforms to close the many loopholes and lacunas that now riddle the system. The court should also explore ways to bolster its own capacity to act as a check on the other branches in cases of suspected lawlessness. This could include creating a permanent special master or ombudsman within the judicial branch to investigate complaints of governmental non-compliance with transparency mandates and other legal constraints. It could also involve expanded use of the court's mandamus and supervisory powers to proactively enforce such mandates rather than waiting for the perfect test case. More broadly, the court should use its bully pulpit to spark a wider conversation about the health of Nebraska's civic immune system. It should seize this opportunity to educate the public about the vital role of open government in preserving self-rule, and the stakes of allowing a culture of secrecy and non-accountability to take root. At a time of mounting cynicism and alienation, rekindling popular faith in the rule of law will require a judiciary that leads by example in demanding transparency from the coordinate branches. Ultimately, of course, no amount of judicial exhortation or institutional tinkering can substitute for a renewal of Republican virtue among the state's governing class. For accountability to take hold, Nebraska's power elite will need to rediscover the habits of humility, service, and deference to public opinion that are the lifeblood of representative democracy. They will need to relearn the art of seeing themselves through the people's eyes and submitting to popular judgment, an art that decades of deepening insulation have taught them to forget. But this court can be the catalyst for that cultural sea change. By modeling unflinching enforcement of the people's right to know and to check abuses by their temporary agents in government, it can begin to restore the healthy fear of exposure that is the best disinfectant against corruption. By refusing to countenance the sacrifice of substantive justice on the altar of procedural mumbo-jumbo, it can lead the way back to an ethic of public service that puts openness and responsiveness first. In the end, there may be no task more vital to the long-term health of our civic order. For as this case illustrates in microcosm, what is at stake in the struggle for transparency is nothing less than the survival of accountable government of a system where the ruled can know and check the rulers, and the law is more than a mirage of words to be parsed by a cloistered elite. A renaissance of popular sovereignty in our time demands a judiciary that sees itself not just as a neutral umpire, but as an active defender of the public's right and capacity to know. That is the role petitioner now pleads for this court to embrace. The voluminous record of dysfunction before it, though dispiriting on its face, is also an invitation to rise to the moment and arrest our democratic decay. By taking up that mantle and blazing a trail of transparency in this case, the court can be the stone that starts an avalanche, the force that begins to shake Nebraska's sclerotic governing class out of its dangerous complacency. Of course, no single ruling or reform can hope to unravel a culture of UN accountability decades in the making. But this case offers a uniquely resonant opportunity to catalyze a wider reckoning and set a tone of urgency from the top. If there is still a flicker of self-correcting potential in our institutions, it falls to this court to breathe oxygen on the embers and show the way. The hour is late, but not yet past. 8. The costs of inaction transcend this case. In the final analysis, this case is about much more than one man's grievances or even one state's institutional dysfunctions. It is a microcosm of the broader crisis of legitimacy that afflicts our nation's civic culture, a canary in the coal mine for the slow-motion collapse of government of, by, and for the people. What petitioner has exposed, through great personal sacrifice and against all odds, is a system that has profoundly lost its way, a system in which the powerful can violate the law with abandon, in which watchdogs and judges alike slumber through the most egregious betrayals of the public trust, in which elections and hearings are kabuki theater for a script-writing process behind closed doors, in which equal justice under law is an empty slogan papered over a monstrous reality. Left unchecked, that reality will be corrosive not just to Nebraska's civic health, but to the basic social contract of our nation. As James Madison warned at our founding, no constitutional design can long endure without auxiliary precautions to keep would-be tyrants in check. Federalist number 51. Absent a robust ethic of public service and a vigilant citizenry ready to hold officials to account, any system of representative government will eventually decay into oligarchy and oppression. Petitioner's case is Exhibit A for that decay in our time. It shows how far a state can sink when the very institutions charged with upholding the law become its most brazen scofflaws, when governors govern only for their patrons, when legislators legislate only for their donors, when watchdogs hunt only for their master's prey, when judges look only to the next election. In such a world, the corridors of power are walled off from the cries of the people, and self-government becomes a cynical mirage. This court now has a choice. It can look away from the hard truths so painstakingly illuminated here, and hasten that downward spiral to a post-constitutional order. Or it can reassert the judiciary's vital role in our system of checks and balances, stand up for honest government against the headwinds of our time, and begin charting a path back to the nation's highest ideals. That path will not be easy. It will require a wrenching reckoning with the depth and breadth of our democratic decay, an all-hands effort to salvage what remains of our founding principles, and a groundswell of popular mobilization to demand better than the craven servility to which we've grown inured. But if there is any hope for renewal, any prospect of redeeming the American experiment for a new generation, it must begin right here, with cases and controversies like this one. For you see, Justin Riddle is not simply a litigant. He is a patriot, who at great cost to himself has illuminated the decay of our institutions in his state so that we the people might arrest that decay in our nation. In that sense, his struggle is every American's struggle, his fight for honest government, every citizen's fight to keep faith with our framers. The question this court must now answer, then, is not really about Justin Riddle at all. It is about what kind of country we will be, what kind of people we are. Will we be a people that looks the other way as corruption hollows out our institutions and hands our sovereignty to the highest bidder? Or will we be a people that sees such corruption and says, no more, not on our watch, not in our name? Our nation's eyes now turn to Nebraska for the answer to that question. May this high court find the wisdom and fortitude to give the right one for Justin Riddle's sake, and for the Republic's. Conclusion. The writ must be granted. If this court cannot muster the will to act in the face of such overwhelming proof of injustice and lawlessness, it will have surrendered its most solemn duty and consigned its legacy to the oblivion of failed institutions. At the most basic level, this is a final exam for Republican self-governance in Nebraska. Will a government of laws, not of men, pass from an aspiration to an epitaph on respondents? Watch. Will future generations look back on this moment and see a judiciary that found its courage or one that fiddled while Rome burned? So the gauntlet is thrown. Petitioner asks no favoritism here, only that this court apply the sole standard compatible with a free state, a government bound by the law and accountable to the people. May it rise to the challenge, restore the rule of law, and in so doing, show that Nebraska's constitutional constellation still shines bright. Respectfully submitted. Justice